to the legal studies and law courses for law students and lawyers and law lecturers as well. Today we are going to make out legal system terminology in context. I would like to tell that for both the law student and the young practitioner, lawyer, who have not studied law in English, the time may actually nonetheless come when it is necessary to deal with English legal terminology relating to the operation of a legal system. This necessity may arise in various guises. The law student may find, for instance, that he or she has to study English or American cases as part of his or her coursework. Reading these actually law reports, which I'm going to display you, requires not just an understanding of the legal issue dealt with in the case, but also of the operation of case law in common law jurisdictions. So, to give a clear illustration, the student needs to be able to distinguish what part of the case report sets out the binding precedent and what parts are obiter dicta. Actually, I would like to show you binding precedent and obiter dicta. And it may also seem strange to some students that the opinion of a judge who does not agree with the majority decision is still reported. With respect to the young practitioner, the student will often find himself or herself in the position of having to explain the operation of his own legal system in English to a foreign client. So translating the workings of a civil law system into English, common law, terminology can be extremely difficult, complicated, as all those who have ever attempted it will know. The reason for the complexity is simple. Translating from one system to another system is far from straightforward. When, for instance, a Dutch lawyer has to explain his legal system to a common law lawyer, it's not simply a matter of replacing Dutch words with English words. Actually, the Dutch system is not a carbon copy of the English system, you should know that, which means that there will not always be equivalent English terminology at hand for translation purposes. In order to use English legal terminology correctly and effectively, the practitioner must not only be familiar with his own legal system, but also have a basic grasp of the structure of the common law system. Actually, the English legal system is a common law system. So the common law developed in essence as a system of case law. Authoritative decisions were laid down by judges in court. Over the course of time, the doctrine of binding precedent developed, which means that decisions made by judges in the past should be upheld by judges in new cases if these new cases showed marked similarities to those that had gone before. When the English set about establishing colonies, this common law system was often implemented in the colonial regime. Although there is no longer a British Empire, the common law system has remained in force in various former colonies, for example, in the United States, Canada, and Australia. So let's move to the common law system once again. The common law system should be distinguished from the civil law system. Civil law systems are coded systems, the law being laid down in written form. Civil law has been heavily influenced by Roman law, although it would be incorrect to assert that Roman law has had no effect on the common law. Its impact has been considerably less and more indirect. The code drafted under Napoleon in 1804, the code Napoleon must also be acknowledged as a source and example for many civil systems in Europe and beyond. The common law and the civil law are often treated as two entirely different approaches to the practice of law. Not Notwithstanding, these two systems are not as worlds apart as some lawyers maintain. Actually, codes will always have to be interpreted, and that will necessarily generate case law. And anyone who thinks a common law system derives its only law from the courts actually would be very wide of the mark. Actually, in our following lessons, you will be sure that legislation plays a vital role in all common law systems today. So, the term actually civil law can be confusing. When the term is applied to a legal system, it refers to a coded system of law. However, civil law is also used to refer to a type of law. Let's say private law. Private law or civil law refers to legal actions brought between individuals. Its purpose is to settle disputes between individuals and to provide remedies. Public law, on the other hand, regulates issues relating to the state and society. For example, criminal law. And as I already explained, the basis for all terminology will be English law, as all other common law jurisdictions have grown from English roots. Should be in mind. These common law jurisdictions have developed in their own way over the years, and although there is still a substantial body of shared terminology, variations in development have led to certain terminology being relevant to some but not necessarily all common law jurisdictions. To give the reader an indication of how terminology may vary, actually the United States has been selected for comparison. So your attention will be paid to the terminology of three elements associated with the legal system. These three elements are the administration of justice via the court structure, then the second one, the legal profession, and the third one, the operation of a common law system. So I would like to talk a bit and briefly about the court structure. So trying to find a good English translation for the name of a court in a various law system can sometimes be quite difficult. For this reason, actually, the following our lessons describe the courts and their competence in the English and American court systems. It is common to find the names of the US federal court system used for translation purposes. In general, the highest court in the land is usually translated by the term Supreme Court, the appellate court level by Court of Appeal, and the trial initialization level by District Court. So court systems vary from land to land, and sometimes there is simply no equivalent in the Anglo-American system for a particular court in another system. So I would like to mention that our following lesson will also be regarding legal system, legal studies, and law for lawyers, practitioners, and law students. So do not forget to subscribe to our YouTube channel for free lessons for all Cambridge exams and law courses. And you are welcome to send your request to our email address, and we will feedback you as soon as possible. So that's all for this first lesson.